utolsó előadónk már itt áll a célegyenesben és a start vonalon áll, és Schmidt Laci egy, ha jól tudom, a római főpróbája következik, jól sejtem? És Thoughts on Humiean, Kantian and Legal Causation, tehát egy angol nyelvű előadást fogunk hallani, kantiánus, humiánus, és hát az okság, ami egy kulcsfogalom mindkét gondolkodó esetében, tiéd a pálya.
So, last but not least, welcome everyone. My name is László Schmidt. I work as a junior judge or assistant judge in the Szekszár District Court in the Civil Law Division, and I'm also a second year philosophy PhD student in the Philosophy Doctoral School of Pécs. Today, and first of all, I would like to thank you for the organizers for the opportunity to be here today. Today, I'm gonna give you a very short overview, only overview, about the Humiean, Kantian, and legal causation. So, causation, why we talk about causation, why is it important to us, either in philosophy, either in the area of law. In the philosophy, causation is in a central place in the philosophical thoughts, in the philosophical thinking from the very beginning. However, causation is a so-called essentially contested concept, which means that there is no universally accepted definition of causation, either in philosophy, either in our everyday life. The philosophical thinking and the philosophy itself works like that, asking the question or questions, trying to answer those questions, but when it answers the questions, at the same time, new questions arises, which has to be answered as well, and so on, and so on, and so on. But contrary to this, the legal practice, especially the court practice, has to be pragmatic. Because at the end of the day, the courts must deliver judgments, so the legal practice, the courts cannot always asking the questions, but at some point, sometime, somehow, they has to have answers. The legal causation is very important, both in criminal law and civil law as well. Within the civil law, it is important in two areas, the area of breach of contract and in the tort law. Lots of theories developed in the legal thinking, how we could understand, how we could grasp the causation, how we could cut the chain of causation. For example, the sine qua non test, proximate cause, foreseeability, and so on, and so on, and so on. So, according to Hume, two phenomena necessarily related if we cannot understand one without the other. According to him, we can understand causation through our experiences. So, according to Hume, causation is a posteriori. He developed the so-called regularity theory of causation, which means that C, the cause is E, the effect, if and only if C is cause is contiguous in time and space with E. If E follows, if effect follows cause in time, and if all events of type C regularly followed by events of type E. According to Mario Bungay, however, Hume did not say that the effect is produced by the cause. Hume only said that effect regularly associated with cause. And Moritz Schlick emphasized that we shall not treat regularity and causality as equals, because they are not equals. In his example, The changes of day and night are regular, but they are not in a causal relation. As it was told before today, Kant made the so-called Copernican turn in the philosophy because he said that the focus should not be on the word itself, but it should be the subject of the man. How can we think, and how does our brain, our mind work? According to Kant, causation is not derived from experience, but only from pure understanding. So according to him, causation is a priori. It is a synthetic a priori judgment, which means that we know it from pure reason alone, and it is independent from experience. According to Kant, succession is not necessary, and he emphasizes that the effect not merely follows upon the cause, but posited through the cause and follows from the cause. In his example, if we say that a body is illuminated long by the sun and becomes warm, there is no necessary connection, so it is not a concept of cause, it is only a subjective connection of perceptions. If we want to make it as a judgment of experience, then we shall use necessary and universally valid notions, words, and so on. So he transformed the sentence and said, the sun is through its light the cause of the heat. So in this way, this is a concept of cause. According to László, the Kantian causation could be interpreted as follows. The law of causality is not about whether the world is causally structured, nor even about whether the phenomenal world functions causally, but about the fact that phenomena, or more precisely the changes observed in the phenomenal world, are interpreted by the mind through the category of causality. And now we arrived at the legal causation. The main role of the legal causation is to establish the legal liability for someone's act or omission. We have to differentiate between two notions of cause. The one of it is the cause in fact, which is a scientific question, whether the chain of causation, the causal link can be established or not. The other one, the so-called legal cause, is an evaluative thing, and there is no clear definition for it. As I told you before, there are lots of theories how we could understand the legal cause, how we could grasp the so-called legal cause. For example, the sine qua non theory says that all necessary conditions are causes. The so-called but-for test is a counterfactual test and asks the counterfactual question, but for the defendant's action, would the victim have been harmed as she was? According to the theory of adequate causation, if the harm is recognizable to any reasonable person, then the defendant shall be held liable, even if the particular consequences themselves were not recognizable to the given defendant. The test of the objective forcibility excludes unusual results, unusual effects, result linked to conduct as a cause. In Hungary, the Hungarian courts consist about that it is enough for the defendant to anticipate or to foresee only the nature and the scale of the damage. So the defendant should not see through the whole chain of causation the exact kind or the exact amount of the damage. It is enough to establish his or her legal liability if he or she could foresee the nature and the scale of the damage. According to Hungarian Supreme Court, however, liability cannot be established for the occurrence of circumstances that cannot be precisely determined in advance, and regarding the chain of causation, must consider whether the initiator of the chain of events leading to the harm saw or could have seen the result. So could have seen the result means that we put someone reasonable man in the place of the given defendant, so we can determine whether he or she is liable for his or her acts or omissions. And despite the fact that in the beginning of my presentation told you that court practice cannot always ask the question, I will leave you with a question because I found something in the Hungarian Civil Code which, in my opinion, there's a little bit of problem with it. I found two official translations, so that's why there's two translations, but they are more or less the same. So, according to the Hungarian Civil Code, no causal link shall be established in connection with any damage which the person causing it could not foresee and should not have foreseen. Or, no causal relationship shall be deemed to exist in respect of any damage that the tortfeasor could not and should not have foreseen. And my question that is it a proper wording? Because, in my opinion, the legislator did not do it exactly properly. Because I think we cannot say that no causal link or no causal relationship can be established, because there could be established. But if we want to say that we don't want to hold the defendant liable for these kind of damages, then, in my opinion, we could say that the tortfeasor cannot be held liable for damage which the tortfeasor did not foresee and could not have foreseen. So we don't say that there is no causal link or no causal relationship, but we say that the defendant shall not be held liable for those kind of damages. And thank you for your attention.